Yeah. The whole removal of the Chief Justice issue is really so many different issues around our constitution process. And I think that in a way, in a positive way, it's good that the CRC process is also happening at the same time, because I think some of the issues that it has raised, I don't think people have sort of put their minds to it. So, for example, the argument that's been made around the prima facie, issue, which I find it interesting, because if you read the Constitution, when prima facie is used in this context, it's really just like an Iyoko making a preliminary determination that should I go ahead and investigate this matter. It is not in the court sense of some sort of a legal standard for saying that is there enough evidence for me to go forward and adjudicate this particular case. But in a way, the way the lawyers are talking about it, it seems like the two have been, it's almost like it's considered as a judicial process, right? So the question about should the Chief Justice have seen the reasoning of the President and the Council of State on why they decided to make a determination of prima facie, and then proceed to propose or recommend that she be suspended. And that is a question, because if I think those who have even looked at like the Kenya one and so on, it just basically doesn't even use the words prima facie. It just basically says, on the face of it, these allegations that are put, are they substantive enough for you to investigate? Because the body that is supposed to be created afterwards is an investigative body that then comes to a determination and make a recommendation, to the president one way or the other. The second point is that the issue of suspension, which in a way is also then presented as a punishment, almost like, because you have made a prima facie case, we feel that you have done something wrong and therefore we are punishing you by suspending you. But the suspension, you could have easily substituted that with recusal. Because of the particular nature of the process, you are talking about investigating a Chief Justice. The idea that the Chief Justice, once you have determined that you should go further to investigate, will still be sitting on cases and exercising her powers as Chief Justice, create so many problems for conflict of interest, for ethics, for whatever. So it makes sense that you will say, recuse yourself whilst this process is going on. So for example, in this case, Justice Tukonu, just before the suspension happened, was the one that empaneled the judges that were supposed to hear, I think the first case, the Asafwa case, for example, right? So how would she have played that role if she was still in power for all these cases that have come? That she will be empaneling justices to go and hear cases injuncting the process that she is currently being investigated for. So I think that there are like problems with the way in which the whole process has been structured. But how do you correct that while the process is going on? It's almost like you can't stop midstream and address those challenges, as it currently stands. So for me, I don't think those who make the case of prima facie, I think the way they are judicializing the process too much, and I don't think there's merit in it.
The point is that precedents show, and I have the benefit of being involved in at least two situations. The precedents is that they would normally give a reasoned decision in the prima facie. So the prima facie can be 3 pages, 4 pages, but those I have seen, they are more than that. Sure. Mm-hmm. And you can read, and you will see in the prima facie that it says, your accuser says you have committed 10 sins. Mm-hmm. We find merit in 2, 3, 4, 3, 4, or 5 of the sins. Yeah. The others, we don't think they are. So now the committee has been set up. You come and you respond to those that prima facie has been made. That's her concern. Sure. So now you say I should come. Yeah. And I don't know which ones I am answering to. Is it not fair?
So that's what I was saying, that for me, the way I understand it, and what has happened since the process began, is that we are almost imposing setting standards in almost like we are in court. You see, if you look at the way the Constitution is clear, that's why they didn't say the Chief Justice should, it should be a panel of judges that should sit on the. They said you should bring people who are not loyal, who are not this. This is obviously intended to be a process that is not judicial, or one would say it's quasi-judicial. So there are processes that at the beginning that you would say that if the president and the Council of State did their whatever preliminary, whatever, made their determination, and at the investigation stage, the investigators came and said, oh, this is the issues that we are going to deal with, right? They didn't give it to you at the time of when the determination was made. You are not going to say, well, because I didn't receive the reasoned judgment, therefore the process should be vitiated. That is where I'm having a problem with, because I think that once you do that, it means that even at the prima facie case, you can go to court and now start to interrogate or dispute the reasoning. Because what will stop the Chief Justice, for example, after receiving it, to go to the process? I don't think the grounds on which they made the prima facie is right, and therefore I am challenging it.
She also wants a public hearing. How about that?
Well, so the public hearing one, so we know that the law, at least what I've read, is very clear in terms of the fact that it should be held in camera. The argument she's making is that somehow she has an inherent right to, or inherent right, I don't know whether it's a right of speech or whatever, that she can waive. I don't think the Constitution does that. I don't see anywhere in 146 where that right is given. If that right is a general human rights, then maybe you can go to the High Court and say that even though it has not been introduced in the process. But it is not just about her rights. And this is the other thing that we have to accept about the 146 issue, because the issue, even with the high security and the challenges she's having with the security screening and all of those kinds of things, is that particularly because when this case started, the leakages has been so rampant that if you were going to succeed in holding it in camera, you needed to find something that is secure. She was saying that ordinarily is held at the court premises. But that was cases where she, as Chief Justice, she was the one conducting the investigation.
Or other Chief Justices
conducting it. But this is involving you.
They were not exactly conducting. They were only
the one that were, yes, basically, right? So it was under the supervision of the Chief Justice, one would say. So for the Charlotte Osei one or even the other one. But in this case, of course, it's you who, another committee that necessarily is not sort of the purview of the...
So why do you take it to an abandoned castle, abandoned presidential...
I don't know.
Abandoned slave dungeon or slave...
I don't think... Annex. I think I've been to the office of the president annex, I think when it was being used, and I don't know which room they are, but I don't know when they say it's cruel, like the environment. I don't know. I don't see what is it about
treated
the room.
Like she's committed some treason of sorts.
I've seen what...
That's where she stands.
I've seen how the people who were brought for treason, the police officers said, there's no anything like that. I think and just to try and wrap up, what I worry...
People may be surprised hearing from you, because you wrote an article that, sought to uphold her rights.
No, my article was very clear. My article made the point that the issue that we have in terms of whether you have perception of bias of the Chief Justice is not the person that is there that is the problem. It is the governance framework we have set for the Chief Justice that if you replace this person with another Chief Justice, you are going to have the same problems because the discretionary powers. And so I think that for me, that point, but it's the issues that are being raised now, like if, for example, you are before a commission of inquiry and you think that there are problems with the rules that have been set, how do you address it? Are there mechanisms within the commission of inquiry rules that allow you to address it? Like if you say, I feel intimidated or I feel that this room, I would like this room, the committee can decide yes or no. At that point, can you go out of the process and say, go to the Human Rights Court and say, no, I cannot bear this. Like I can't continue in this way and therefore intervene. I think that is where it's an interesting legal question because this process is final. Unlike other processes where you can appeal.
You can't even allow her husband to keep her company in the process.
Yeah, so within that process, that's what I'm saying.
From where you said, can you tell us what is lost if her husband was allowed to be with her?
I don't have
at least not her daughter, but not her family, but just the husband to be with her.
I don't have any problem because I think those are something I'm asking myself that in the committees, the committee is supposed to do its own rules, right? Of course. Consistent.
Only the parties, the accusers, their witnesses, the accused, quote unquote, the respondent, and their witnesses are allowed, and their lawyers are allowed.
Yes, that's what I'm saying.
If you make an exception to allow her husband,
that's what I'm saying. The committee, those things are very basic, and I don't understand why they exclude that, right? Even the question about whether petitioners themselves should present themselves rather than their,
witnesses.
What you would think that, yes, I want to face my accuser, right? Somebody has that right you want to make. So, but what I'm saying is that when that is going on, in a process where you cannot appeal, right? How do you deal with that? Because once the process is finished, you can't go and say you are going to appeal in this particular case. In other processes, you can go back and say, because of what went on, basically vitiate the
unanimously the supplementary statement which had all these complaints was thrown out.
It was thrown out
because it was disclosing the private issues.
So, which is a very narrow way.
Was it your expectation that this will happen?
No, this is almost like a technical
knockout,
a withdrawal of the jurisdiction of the Supreme Court. The Supreme Court is saying we cannot enter into it. So the matters that are even being discussed has not been touched at all.
Okay.
But the point I just to finish off was that certainly this process has flaws, and we need to find ways to deal with it. The only issue is that as we are now, there's no way in which you can stop this process midstream.
All right.